Court gives final sentence to former president of O. Cool Company, Limited for providing hyperlinks to pirated films. The former president and former chief technology officer of O. Cool Company, Limited, hereinafter referred to as O. Cool, who are surnamed Liu and Wang, respectively, had jointly developed the apps, hereinafter referred to as the infringing apps, that are able to intercept and get access to, through computer programs, the links from a third party's websites to enable the infringing app's users to link to external source to watch films. From July to August 2016, there was another person who, without the prior consent from KKTV Company, Limited, hereinafter referred to as KKTV, holding the exclusive right of public transmission for two specific Korean dramas, publicly transmitted the two Korean dramas to YouTube or Dailymotion, and the infringing apps added the links to the two dramas into the VOD playlist, Video on Demand playlist, and thus, enabled unspecific users of the infringing apps in Taiwan to watch the two dramas. Against such an act, KKTV sued O. Cool, Liu and Wang for Copyright Act violation, and the prosecutor indicted the defendants therefore. The Taiwan Taipei District Court found the defendants not guilty in the first instance proceedings on the ground that Liu and Wang was engaged in the act of providing hyperlinks to unspecific users in 2016 when the act was not officially created and established as equivalents to Copyright Act violation until May 2019 when the Taiwan Copyright Act was amended to include the act of providing hyperlinks as copyright infringement. The case further moved to the second instance proceedings at the Taiwan IP Court, which held that the act of providing hyperlinks does not constitute public transmission, and that the offense Liu and Wang committed was that of assisting another person in infringing KKTV's economic rights and to the said two Korean dramas which were uploaded by that person without KKTV's prior consent. Moreover, the IP Court ruled that according to the amended Copyright Act, amended in 2019, the act of providing hyperlinks is directly established as infringement as clearly stated in the provisions, which does not mean that the act of providing hyperlinks before the amendment does not constitute commission of an offense. Based on the foregoing reasoning, the IP Court sentenced Liu and Wang to detention for 2 months and 40 days, respectively, which may be commutable to a fine payment. On the other hand, O. Cool was ordered to pay a penalty in an amount of 100,000 Taiwan dollars, for its representative and employees at that time committed the offense of infringing another's economic rights during the course of performing business duties. O. Cool, Liu, and Wang appealed this case to the Supreme Court, but the appeal was dismissed. This case was concluded accordingly.